Ladies and gentlemen, we left off in the discussion of the bloodstain pattern analysis. And what was an interesting moment in terms of the experts was when there was talk of bloodstain inside the zipper and around that area. But if you look at the DLI report, which is number 169, you'll see in that report they were looking actually for touch DNA. They weren't actually looking for blood staining. They identified blood staining, but the whole point of it was to find Brendan Banfield's touch DNA on the inside of Joe's pants based upon some theory that he was either pulling the pants off or moving them or something like that. And that was one of the reasons why they went to a private lab to try to do that, and it didn't pan out. And you'll see the report. Now, in terms of the evidence on the bloodstain pattern analysis, let me just do a rundown. With regard to the knife, it was identified as being bloodstained. Leanne Singley said that. She negated the possibility of anything being wiped off, which might be one of the things that you might find in a situation of the nature of the government's theory, but she's negated that. That it contained DNA of Christine and Ryan, and Brendan was excluded. That Joe Ryan's DNA at the base of the blade, handle juncture, that was the testimony of Leanne Singley and also confirmed by the Division of Forensic Science. That Ryan had a puncture to the left thumb, that was Leanne Singley's testimony, as well as the medical examiner, Dr. Kessler, confirmed that. It was consistent with the knife, Dr. Kessler said, and it was consistent with the self-wounding that happens in situations involving stabbings. And you heard Leanne Singley touch on that, she was able to kind of give you a more circumspect view of what self-wounding was. I think Ms. Groff talked about slicing, fingers or it sliding or something like that. What we were looking for, and what I think Leanne Singley was able to tell you, is that there are a wide variety of injuries that occur, but oftentimes the stabber is someone that's injured. And I think there were significant statistics that she talked about, which I won't try. You'll have to rely on your recollections regarding that. You saw on the body cam footage, as well as through Ms. Singley's testimony, that Brendan does not have any injuries on his hands. And Ms. Dolly's testimony indicates Ryan's right hand closed when blood was deposited on it. That's consistent with Ryan holding the knife when stabbing, causing blood stains. Joe Ryan, there's a lot to be said, and I think you've already seen pictures of it in this closing, of the 4 stains on Ryan's forearm. What hasn't been said is that they were not tested. Leanne Singley says they're not able to be classified. Ms. Groff disagrees, saying that they are drip stains. She needs to say they're drip stains, which Leanne Singley says you can't say because you don't know the position of the arm, you don't know where it was at the time the blood came out. It could have been something from a significant bleeder as he's standing up. It could have been from numerous other possibilities. But Ms. Groff classifies something that Ms. Singley says you can't classify without certain factors, suggesting that it's falling from above and has Ryan on the floor. One might think you'd find the source of whatever that blood is if you're to have tested the blood that's in question. That might give you a little more guidance. And I think that's one of the reasons Leanne Singley was unable to identify that. If it was from Joe, then she'd probably have some explanation for that as an expert. If it was from anyone else, that perhaps could be a different explanation. But now all we deal with are possibilities. And that seems to be the crux of how the Commonwealth is pursuing this case. They're not putting on any evidence in terms of their own investigators. They're not providing any concrete evidence as to what happened that day. And interestingly enough, the shift in the last closing argument was that I hadn't been doing that. And the defense hadn't been doing that. But I think we can all agree that we've called significantly greater number of police witnesses because we had to. Because we want the truth out here. I called my client, though he has the absolute right not to come up and testify. And he testified. And the relationship issues with Juliana Perez Magalhaes are touchy, and they're an awful story. But he sat there and he answered the questions. He was cross-examined. He answered those questions. We're bringing you the truth. We're trying in every way to get the truth. And many of the Fairfax County detectives have provided that, and that goes to their integrity. The genes, the touch DNA from the waistband zipper indicate Joe Ryan and Christine Banfield are the contributors. Brendan Banfield is excluded. All samples collected and tested on Ryan were from Joe Ryan or Christine. Brendan not identified as a contributor in any of them. Nothing in the materials reviewed gave any indication that Ryan was not the stabber. That was Leanne Singley's testimony. Brendan's jacket, blood on the rear of the right sleeve, DNA on exterior of right sleeve, mix of Ryan and Christine. Brendan indicates that Ryan grabbed his arm. On Officer Beckner's video, Officer Baumler's video, in the ambulance, and also in the hospital. Brendan's jeans. The small stains on the thigh is consistent with cast off from the hands. That's Miss Dolly, Miss Groff. Brendan sat in the bathroom, if you look on the video, and the first responders arrived. He was basically told to sit on the tub, and you see him when you look at that video, and he's sitting there, and he's just, hands down, not sure where his hands go, and he was watching as his wife was being tended to. The stains on Brendan's jeans are consistent with him kneeling at Christine giving aid. That's what the body cam video shows. Back to the digital forensics for a moment. February 19th was a critical day because that was the beginning of the Telegram account. Juliana says she watched Brendan. They stole the laptop and the phone. They deleted the two-factor authentication code, but the two-factor authentication code remains on the phone to this day. And this is Defense Exhibit 156. Is it possible that Brendan and Juliana did this without Christine knowing that a Telegram account was opened in her name? It's not, based upon this exhibit. Because if you look at it, and you can look at the message from Telegram, shows up right underneath a message from Brad of Inova PICU, and right above a message from Nicole at Inova PICU. It was done early in the morning. If it had been done by someone other than herself, as soon as she looks at that message from Nicole, she'd realize something's going on. I should check this out. Inconsistent with catfishing and consistent with someone pursuing a fantasy. February 23rd. We saw digital forensics evidence from the evening of February 23rd. We saw use of Christine's laptop for 90 minutes for resort searches, with a couple of minutes of Telegram use interspersed. The Commonwealth in cross-examination opined, well, wouldn't it be possible that even if you were sitting in the same room, that she could have gone away to go to the bathroom for 2 minutes? And I guess, you know, in this world, anything's possible. Is it probable, however? And that's really the more germane point to this. The Commonwealth's, I guess, concern in cross-examination was confirmed, at least in terms of the room, when Brendan testified. And if you recall his discussion, we were talking about, we were already going on a cruise and we were talking about going to the Dominican Republic. We saw the calendar that showed the place, Royalton Resorts. We showed the searches that showed kid-friendly vacations. So we knew who was behind the keyboard, and Brendan knew who was behind the keyboard because he was there with Christine. And they were collaborating on the vacation research. Brendan was playing with Valerie, and Christine was on the couch with her laptop and her phone. That's the testimony. The device's symmetry and connectivity you heard about has the context to complete the entire picture. Juliana was not in the room, and this is supported by the analysis on her phone, showing a steady stream of messaging, social media use, and Netflix at the same time that Telegram, FetLife, and the suspect Gmail account were being used by Christine. And finally, February 24th, Juliana was not awake, not out of bed, based on her devices at the time she claimed to be watching Brendan Banfield sending messages in the kitchen. You heard Mr. Litsky talk about her Apple Watch. You heard him talk about her phone. We're showing when steps were showing, which would be an indication of someone moving. She had not moved for some time after the laptop was accessed. What we know from the testimony yesterday was that Christine Banfield had the laptop and the phone in her bedroom and was awake when he went up to retrieve Valerie. That is an artifact in the world of digital forensic analysis. And you'll see this entire exchange, Defense Exhibit 348, 349, 350. you'll see Juliana Perez Magalhaes' first steps at 626, Defense Exhibit 351, 352, and 353. Juliana Perez starts her day after the telegram message is already sent, in conflict with what she's told, in conflict with the story that she's adopted on behalf of the Commonwealth. Brendan's at McDonald's. Exhibit 354, 355, 356. Those are time-stamped screenshots from the McDonald's videos. Juliana is on the phone telling us her phone tells us that her activity stops at 7:24 under Defense Exhibit 357. At the exact same time, her watch steps are stopping at 7:24. Defense Exhibit number 358. Defense Exhibit 359, Juliana steps resuming on the phone at 7:41. Exhibit 360, Juliana, car is parked at 7:41. Exhibit 361, Juliana's watch resuming steps at 7:42. We know that Brendan was out of the house. We know that Juliana was in her car. And if you look at Exhibit 362, there's someone who's logging into Christine's laptop at 7:33. There are no other humans in the house. And Juliana and Brendan were not there. In conflict with the government's theory, Christine logs into her laptop and places her devices in a drawer. She puts the devices away. She gets Lily down into the basement, brings her food to the basement, and gates her in. And she meets Joe Ryan. And they walk up to the master bedroom. Why? Why would Joe Ryan stab Christine? If you take away the consensual part of this, if he were found in a bedroom of someone by someone who's a police officer, he'd be looking at a life sentence. In this instance, he was confronted by an armed law enforcement officer saying, "Police." That officer was standing in the only way to get out of that room, other than jumping through the window and falling down 3 flights. He had a gun trained on him, and he was telling him and was told that he was going to be arrested. He had marijuana in his system, and he was angry. Who was he angry at? Could he have been angry at Christine, thinking that she set him up? Could he have been angry at his situation for deciding to go into a house that he didn't know and put himself in this situation? Could he be angry at my client, who was there to try to figure out what was going on and ultimately try to protect his wife? Those are the whys. And if we'd had any investigators that were actually involved in the case coming to the stand, those would be questions that I would want to know, and they would be questions that you would want to know. Because you have a decision before you, and that decision requires a review of all of the evidence. Now, is it reasonable after a 6 to 8 week affair that someone's going to try to get rid of their companion of 19 years, wife of 12 years? Is that reasonable? You heard from my client, he thinks it's absurd. In pursuing this case, the Commonwealth has presented absolutely no forensics evidence that supports that Brendan Banfield had anything to do with this, yet the story continues. This isn't how justice works, and you can't just come up with a theory and make it fit. They're trying to sell you a story without any facts. And we have the facts, and those facts are in evidence. Those jury instructions, when you see them, you'll realize they're very clear. If you have doubts about the investigation, if you have doubts about how they've conducted this investigation, if you believe that there's something that's been held back in this investigation, that's reasonable doubt. That's reasonable doubt before you even get into the things that negate the possibilities of their case. And these are hard decisions. There's a lot on the line. But know this, if they fell short in what you expect should be the investigation, if they fell short, that's not on you. The jury instructions say you must acquit. And it's not on you. I don't have another opportunity to talk to you. It's their burden to prove this beyond a reasonable doubt, so they get the opportunity to speak. So I apologize if I've gone too long, but I wanted to make sure that these important issues came before you. And might leave you with these words. When they lie and manipulate to get someone to make a statement, that's not discovering the truth. That's planting the truth. Ladies and gentlemen, thank you for your attention. Thank you for your patience. And at the end of your deliberations, I ask that you find my client not guilty of all charges. Thank you.
All right. Rebuttal argument. Switch over the mic again, Mr. Carroll.
Thanks. All right, just a couple of last words. Mr. Carroll has a really interesting recollection of the evidence. It certainly doesn't match ours, and I'm guessing it doesn't match yours. FYI, the lab for the coat was 165, not 167. And the DLI lab, it doesn't say anywhere on it that it was touch DNA. It was blood that they tested. Juliana did not repeatedly say that she didn't know how to work Gmail. She said that she did not create the Gmail account, that was Brendan. Giaccio and Bruce had the catfish plan and they peddled it and pushed it to everyone. I don't think that's at all what came out. I think that Mr. Carroll is trying to focus on the HR woes of the Fairfax County Police Department to distract you from the fact that the evidence actually supported that theory and that he has provided you and his client has provided you with absolutely nothing to refute that theory. Why was there so much discussion and disagreement over the digital evidence? Because it could never be that smoking gun. You all heard it from their expert. You can't put someone behind that screen unless you're sitting next to them. So as much as we want it to tell the story here, as much as we want it to be the perfect evidence that proves beyond a reasonable doubt that this thing had to happen, the digital evidence just isn't that. We wish it were, but it's not. And Detective Miller did nothing wrong, and Mr. Lidsky did nothing wrong. They just told you the truth. And the truth is that they can tell you what a device was doing, but they can't tell you who was using the device. Juliana Perez Magalhaes' testimony was bought and paid for. Yes, she pled guilty to a lesser offense in exchange for her testimony. Ms. Frissler made sure you knew that from the get-go. Juliana talked about that. She explained for her reasons why. Nothing was hidden. After her sentence, it sounds like she might have the opportunity to make, 10 grand off of selling her story. She said that she would use that to support her family. And then what? Is she gonna work as a nanny? I mean, she's a convicted murderer. Do we really think that it is so reasonable that she made up this complete lie for 10 grand? Really? If this version is correct, coming from Mr. Banfield, then she would be set free. She would be as not guilty as he would be. So she's gonna give up that shot for 10 grand? I just don't buy it. Whose story is more credible here? Juliana's or Mr. Banfield's? Whose version does the rest of the evidence support? The defendant took the stand and he lied. And he lied about collateral matters. He told you that he had a big career-defining work meeting the morning of the murder. And then you heard from his boss who said, no, he didn't. He lied. He said that he and Juliana did not have a plan to kill Christine at the time that they went to the shooting range. Well, he said, not at that time. If he's lying about the things that don't matter, how can you believe a single word he said? And ladies and gentlemen, you have to do that in this case, because without some alternate theory, the Commonwealth's evidence is uncontroverted. So you got to pick one. Juliana, Mr. Banfield. Whose story does the evidence support? All of that blood, the DNA, to some extent, the digital forensics, the physical evidence collected at the scene. That's what you can rely on. Don't rely on his narrative and his recollection of the evidence. For that reason, don't rely on mine or on Ms. Frissler's. Rely on yours. It is your collective recollection of the evidence that you have heard that is controlling. You know what was said here. You know what the evidence is. We trust you to make the decision. Thank you.
Thank you, ma'am. Members of the jury, this is an important case to both the Commonwealth and the defendant. In order to reach a verdict, each of you must agree on that verdict. In other words, the verdict must be unanimous. The first thing you should do when you get back to the jury room is to select a presiding juror. The role of the presiding juror is to see to it that the deliberations are conducted in an orderly and businesslike manner. that they are conducted only in the jury room when all members of the jury are present, and that each juror has the opportunity to fully and fairly express his or her views. It is rarely helpful for jurors upon first entering the jury room to take a straw vote, or for any juror to make an emphatic expression of his or her opinion in the case, or to announce a determination to stand for a certain verdict. To do so before all jurors have had an opportunity to consult with one another and exchange views and opinions might allow your sense of pride to prevent you from retreating from an announced position, even when shown that such position is unsound. You have a duty to consult with one another and to deliberate with the objective of reaching an agreement, if it can be done without offending your individual judgment. Each of you must decide this case for yourself, but only after an impartial consideration of the evidence with your fellow jurors. In the course of deliberation, a juror should not hesitate to re-examine his or her own views and change his or her opinion if convinced it is an error. However, none of you should surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. In the jury room, you will have the exhibits that were entered into evidence. You will have the instructions of law that I just read to you, and you will have the verdict forms. Much of the evidence in this case was in electronic files, so you're going to have a clean laptop that's going to have those files on there for you, and that you will be able to access. And you also have the big TV in the jury room that you can plug in the laptop to that so everybody can view the evidence at the same time, okay? As far as the firearms and knife, the Sheriff's Department has control of those items. If and when you want to see those items, you just have to let the deputy know, and those items will be brought to you. Only the deputy will handle them, but you can ask her to manipulate them however you wish to have them manipulated. But please do not have any deliberations while the deputy is in the room with you, okay? Wait till the deputy leaves before you do that, okay? All right, so during your deliberations until you are discharged from jury service, you must not communicate with or provide any information to anyone who is not a member of this jury by any means about this case. You may not use any electronic device or media to conduct any independent research about this case, the legal or factual issues in the case, or the individuals or attorneys involved in the case. You are not permitted to consult dictionaries or reference materials, search the internet, visit websites or blogs, or use any other tool to obtain information about this case to help you decide the case. Do not try to find out information from any source outside the testimony and the exhibits received as evidence during the trial. You will have, again, you will also have with you the verdict forms. There's 4 charges in front of you, okay? So you're going to have 4 separate verdict forms, all right? Once you have decided, have made a decision, each of the verdict forms should have the foreperson signature at the appropriate place. There's places for guilty and not guilty for each count that you've heard. 2 aggravated murder counts, 1 firearm count, and 1 child endangerment count. Okay, so each form is separately. So each form, upon the finishing of your deliberation, should have the signature of the foreperson just on 1 space on each form. Okay, if you sign both places on the form, it gets confused. If we're confused, then that's not the way it works. Okay, so just make sure you do that. Okay, now for the last part before you deliberate, the fun part. You remember that in the beginning of this case, I told you we had randomly selected 4 people to be alternates. Okay, we still have 4 alternates. Thank you all for your service and being so professional, and even during the snowstorm, making here on time, and we do appreciate that. And let me just say before I release the alternates that I know that this trial has been a huge sacrifice for you all and have taken you away from your lives for 3 weeks now. I know I speak for all of us associated with this case that I want to thank you for your service in this matter. I know it is hard to have come this far and then not get a chance to deliberate, but that does not lessen the respect and admiration that we have for you. As an alternate, you will not deliberate, but you will still be under the order of the court, okay? And so you cannot do any outside research at this time in the case, or you can't talk to anybody about this case at this time because you're still under oath as a juror. That is because if something happens to a juror during deliberations, I will call you back to service and deliberations would start again as you would be part of the jury as well. So that's why you're still under the order of the court. You are under these restrictions and your oath until a verdict is reached. Once a verdict is reached, we will reach out to you and contact you and let you know this has occurred, and then you are free from all your obligations, okay? So again, thank you for your service. At this time, I'll call the alternate jurors, and if you could go with the deputy, you have to collect your items, and we'll get you on your way, okay? So the alternate jurors I have are number 26, number 24, and number 38. So if you could follow Deputy Johnson out at this time. (26, 17, 24, and 38). 2, 3, 4. Okay, so ladies and gentlemen, these are the 12 jurors that are going to be deliberating in this case, okay? You can take as long as you need to deliberate, and at this point, you can take breaks whenever you wish to, and you can let the court know. If you're still deliberating next week, you can let the court know if you want to come in at 9, you can come in at 9, or if you want to come in at 10, that's fine. When you're done for the evening, I know there's one juror that has to be done by 4:30 today, so make sure we respect that timing for that juror. But you can take breaks whenever you wish. You can take your lunch breaks, and you can make them an hour, you can make them a half hour, you can do what you like. It's just important that you do not deliberate at any time unless all jurors are in that jury room at the same time, okay? So during breaks, we don't deliberate, okay? We make sure we take care of that. All right. Do we have another deputy that can? All right. I can excuse you now to deliberate at this time if I have a deputy.
Judge, while we're waiting on that moment, can we approach on one?
Sure, sure.